Okay. Everybody give me a thumbs up that you're listening. Okay, Sterling, you there? Silver, you good. Okay, we're good. Let me just go over a couple of quick details. The next week, I would like to have it's on the calendar. By the way, everything's on the calendar is up to date. So if I change something, I'll let you know. But right now it's up to date. And it shows December, today's practice, last week's practice, and next week it shows a 10 to 12 practice where we actually present the opening statements and then direct witnesses. So is everybody I'm going to need everybody there when we do that. So I need a thumbs up that that's going to work for 10 to 12 next week, which is the 15th, I believe. I'm not looking at the calendar.
I will have to check with my parents, but I will text you later.
Yeah, I need to know, are they available to you now?
My dad is, my mom's the one that's gonna know the schedule,
Okay,
but
that's fine.
but
Just
let me text.
as soon as possible, let me know so we can flexibly work through things because we kind of need to be there to do this. Okay,
Okay, I'm texting her now.
perfect.
It's
Thank you.
next Friday, 10 to 12.
10 to 12.
Okay.
I
I'm
should be, yeah.
I can do it.
I
I should be able to go. Yeah.
Silver, you said yes?
Yes.
Okay, that's great, you guys. We just I'll double check with Olivia and Kayla too, and Kate. I want to go over a couple things. I've asked another person to come on the team, but only to be a reliever for Kate, in case she has to step in and be one of y'all because someone gets sick the day before the day of the event. We can't take the chance. And so I've asked Kate to be prepared to know the cases well enough that she can step in and be one of you guys. Um, and and then in that event, I've asked Hadley if Hadley could be a timekeeper because I don't want to get stuck having to depend on the other team's timekeeper because we need Kate to be a witness or we need Kate to be one of the attorneys. Does that make sense to everybody?
Yes, sir.
Yeah.
Okay. So I just wanted you to know that. I was thankful that Hadley was willing to help with that in that event. So I will list her on the team, but for all, probably it's not going to happen. But just in case we're not caught flat-footed, okay? So
Mr. Moon,
yes,
what is next Friday's practice consisting of?
what we're going to do is practice our opening statements and the direct questions
Okay.
and directing.
Not cross?
No, because we're just going to build this thing slowly. Okay. We'll do the cross and it will take a little longer to do and the cross when we haven't done it before. This is the first time we've jumped into this. So I think it would be better to do first the opening and the direct. And then at the very first practice after Christmas, we'll add crosses to that. How does that sound?
Did you say the week after Christmas?
Well, no. Look on the calendar. I think it's
Oh,
January.
okay.
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 On the calendar, the first practice after Christmas is what I mean.
All right.
And it is accurate there. So look that over and then we will need to do one more full practice between that and the practice match we have on the 18th and the 19th against the team in Houston. Okay. So, but all of that is accurate as of now. So look over December and January and that'll give you the idea. Okay.
Mr. Moon,
Okay. Yes.
I can confirm that I will be able to make it next Friday.
Perfect. Well, we're good then. That'll give us really good momentum going into Christmas. So I wanted to go over that with you. I also wanted to tell you, Mr. Zeiger and I are going to divide and conquer this a little bit. And he is going to take the prosecution team and I'm going to take the defendant team. And we're going to help the best we can to develop your cases and answer your questions. So that way he can focus down, Mr. Zeiger can focus down on the prosecution case and helping with opening statements. And I will take the things that he's going to share with us today, and I will help you all in the defendant team to apply the same things if you're not already doing that. Okay. But we need to try to get ready by next week to be able to have a run through on this from the standpoint of our opening statements and direct questions. Any questions about that?
No, sir.
Okay, Nathan, you on that?
Yeah, that works for me.
So then I'm going to let Mr. Zeiger go from there and talk to you all about some important things about opening statements, direct questions, and cross-examine questions. So Mr. Zeiger, the floor is yours, okay?
All right, thanks. Let's see, prosecution. Let me go backwards here to find the right line. Clear, young. All right. Let me be sure that your opening statement, you have identified what it is that your goal is. And I put it this way: for the plaintiff side, you're representing the Aquatic Center for Exploration. And there's only one way that center comes out of this with a win, and that is if both the jury determines that Nano Design was competent, and that ACE means the Aquatic Center for Exploration. You got to get both of those in there. So your opening statement, I think, needs to focus on where you're going with that. I say that, and I'll comment briefly on the defense side, because I was looking at their opening statement as well. And the defense side wins on two theories. One is that you have he was incompetent to make the handwritten holographic will, in which case Eubanks ends up with a big chunk of $900,000. So that's a win for anybody. The second way is he was competent, and ACE means Alex C. Eubanks. So in your openings, you need to know where you have to end to win. And your opening needs to move in that direction. I felt like on some of these, you could focus a bit more on where you want to end up. And by all means, your last comment on your opening statement needs to be a summation of how this evidence connects such that Design was competent, and he awarded to the Aquatic Center for Exploration, or he was incompetent, or he was competent and went to Alex. And I will comment, the defense has a real burden there, because it's contradictory. I mean, you have Northshire saying he was not competent, and Hamlet saying he was, and you're putting on both witnesses. So you need to really think about how you parse that. Remember, this is a civil case. You're not looking for criminal, and I would emphasize in the opening at some point that the preponderance of the evidence, the greater weight and degree of credible evidence, is what they'll decide, and use that as your opening. Preponderance of the evidence establishes that, and then do your side on that. I was looking at the rough draft of the directs, and I want to point out to you that when you craft a direct, because you are preparing what the answers will be as well. In other words, you're scripting your witnesses' answers. You don't need to ask line by line detailed questions. You can say, introduce yourself to the court and jury. How are you employed? Tell us how you came to be involved in, I don't know, Terry Cloth is the doctor. Tell us about your training experience as a medical doctor. And that one question takes about 5 quick sentences from your witness, as opposed to breaking that down into 5 questions where the witness gives you that sentence in the answer. Does that make sense? In other words, if you say, tell me about your training and experience, you don't have to say, did you go to undergrad school? Did you go to med school? Did you take any training after that? Have you kept up with your medical continuing education? You don't have to do any of that. You just say, tell us what happened. And he gives a quick 1, 2, 3, and then you move on. And that will save y'all over the course of the direct examination a good deal of time.
Okay.
That's important, because that means you have to communicate with your witness and practice a little, so they know exactly what you want them to tell them, and then they are able to tell you that.
Yeah, you as I pointed out, you can do your questions and put into the answers so that your witness can look at that and learn it. Your witness will not be able to carry a document to read, of course, but they'll need to learn that. But they will learn the answers you want to give, and they can go quick. And you don't want to go quick when you get to the meat of the examination. You want to go, but pretty quick until you on the preliminary matters. Second thing you need to do is get your exhibits proven up. The exhibits are stipulated as to authenticity, but that doesn't mean they're admissible. You're going to have an individual identify what the document is and prove how it's admissible under the rules. One of those big issues you have is your order of witnesses. If you have someone like LeClaire or Terry, for that matter, who have to comment on a witness, on an exhibit, but do not have the personal knowledge to prove it up, to make it into evidence, then order your witnesses so they follow that. Defense, you don't have that problem because the plaintiff side puts in the exhibits by and large that you'll be using. There may be some others you have to put in, but just remember that if a witness needs to comment on the exhibit needs to be in evidence. If the witness cannot prove up the exhibit, that is to have it admissible, you need to put that witness behind someone who can. Otherwise, they're going to be drawing objections that the exhibit's not in evidence, that he's commenting on a fact not in evidence. And then when you do put it in evidence, you can't recall that witness. So think through how your exhibits fit. The order of exhibits to prove up is critical. Generally, to prove up an exhibit, and I saw some notes without going into detail, but you ask the witness if they recognize exhibit 1G or whatever it is, and you ask, all right, what is it? And they tell you, and then you tender it into evidence once they've identified it. There could be objections. It could be any number of objections, but most of these written documents will come in without an issue. The field notes in particular, they were in his handwriting. They're there. LeClaire can prove up all of the aquatic center exhibits, the transcripts, etc. Terry Cloth proves up exhibit 6, for example. I don't know how you're going to get exhibit 7 in, but perhaps. I think LeClaire can put in exhibit 8 if he needs to. And you can have your Northshire and Leclerc can both, I think, authenticate, and well, it's authentic, but can prove up Exhibit 9, which is the autopsy report. Cloth, because he's the doctor and reviewed it, and Northshire, because he's an expert and reasonably relied upon. Questions?
No, sir.
Okay.
I actually have a quick question. So I have a feeling that there's going to be some exhibits. One example that comes to mind is the chat between Lung and an unnamed employee of ACE. I have a feeling, because like what you said, because Leclerc theoretically could authenticate most ACE stuff, but I feel like for that you would have to have Jackie, or they would have to have Jackie authenticate that. So hypothetically, if a team tries to authenticate that document using Leclerc, we would just like what would the specific form of that objection look like? Essentially objecting to the wrong person authenticating it.
Yes. Leclerc tries to prove up Exhibit 8. The way I would do that if I were him is to say it's a business record and I'm one of the custodians of the records. That it's a company record, that is something made at or near the time of the event or occurrence by a person with knowledge, that's kept by the company in the regular course of business. The objection to that would be, no, it's a retrieval. You don't normally keep this. You had to go out and find it. Therefore, it's not kept in the regular course of business. And you're not the expert that retrieved it. So how do we know it was accurately copied and presented? The answer to that one is we've stipulated that it is in fact a authentic chat. They're both employees. It contains the information. It contains direct. Yeah, you agree that it contains any and all direct messages between Lung and Jung during the time period. So I would argue that it's we don't have to prove it's anything other than what it is. We simply have to show that it's one of the business records of the company. So the fun part of this one is it really a business record if you had to go retrieve it forensically from the group chat? And the answer might well be, well, I mean, we keep it in electronic form. We have to go pull it out where people can read it. And that's why it was retrieved. So you have arguments both ways, and how persuasive you are on either side will gain you points. Does that help?
Yeah, and so just to clarify, like on Exhibit 8, like hypothetically, because okay, so hold on, this is I'm just trying to sort all this out. So if they used Leclerc to identify it, because as I recall, Leclerc's a prosecution witness. So if they use Leclerc to identify it, objecting on that examination, that would be worth it, even if we know that they're going to answer with that, because it shows it essentially that would be a good thing to object to sort of play for points, right?
Yes, Mr. Spencer, I think that's exactly right, because you're demonstrating that you're making them do the right answer. The other team may not do it right. You're demonstrating that you know what the weaknesses are. And part of this isn't to say, yeah, they'll probably get it right, let's pass. Part of it's to say, you know what it takes to get it right, and you're going to make them do it. And that impresses the judges more than just, well, we didn't say anything because we assumed that they knew how to make it, how to get it in later.
Okay, and that makes sense. And then hypothetically, if they were to use Lung, because part of me feels like it might be a team's instinct to use Lung to prove the authenticity, or not the authenticity because that's stipulated, but to get the group chat admitted. The response to that would be that Lung can't verify this as a company record. with like how hypothetically would we object to that? Just
Yeah. If Lung says he's the custodian of the records, I don't think that's based on his
right. Okay. That
testimony.
makes
I'm
sense.
looking at it. He's the
Pretty sure
he
he's
just
just the
gave
diving instructor.
yeah, he's just a diving instructor. I don't think he's an officer
Okay.
or up there in the company. So to be a business record, you have to be a custodian. A custodian takes many forms. I mean, I'm a custodian
Okay.
of most of the records of my firm, even though I've never seen them because I'm a partner and have the authority to look at and keep. But no one else is the custodian of documents or matters that I may have on my cell phone because no one else has access to it.
Okay. Okay, that makes sense. Thank you.
All right.
Sorry about that.
No,
Good
that's what I'm here for. Question. Who else? All right. The big takeaways for your opening is what are you going to try to prove? How are you going to get there from here? And make sure that your opening starts, middle, and end with a goal toward establishing what you're going to prove. For the defense side, for the prosecution side, that's to say he was competent, and ACE is clearly the aquatic center. And to do that, you separate out. Here's why he was competent. Here's how he knew. Here's the people who'll say, and then you talk about the weaknesses in your case that he, made a couple of slips or this or that. None of that is evidence of lack of capacity. It's evidence of being human, type of thing. I mean, y'all seen me half the time. I forget Nano's last name to sign. I'm still confident, I promise.
Okay. Any thoughts on that?
No, sir.
Okay. Katie, are you with us here? You understand all that?
Yes, sir.
Okay. Sterling, you are you're the defense, right? The defendant?
Yes, sir.
Okay. And Katie, you're doing the opening for the prosecution, right?
Yes, sir.
Okay. So then we need make sure you understand what that opening statement should involve. Real basic. You've heard this before, but just again, you're telling them what you're going to tell them as far as what the narrative, what you're going to tell them is what do they have to believe for me to be right? Okay.
Yes.
In this case, then you're going to tell them, and then you're going to tell them what you told them with that succinct statement, that summary of where you want to leave the jury. The last thing you want the jury thinking about when you're done. And the same thing for each of you, you're just arguing opposite sides. Okay?
Yes, sir.
Is there anything you'd like to add to that, Mr. Zeiger?
No, I like that. That's exactly right. Remember the alliteration, remember rule of three. And part of the rule of three is you tell them what you're going to tell them what you're going to tell them, and tell them what you just told them. Repetition, emphasis is good.
Very good.
There's two rules as well, primacy and recency. And that is people remember the first thing they hear and they remember the last thing they hear. So those should be the two big, you should make your best points to begin and end. And that's same on direct examination. That's same on cross. You have to have a little bit of introduction. But one of the first questions, Terry Cloth, for example, would be based on your training, experience, education, and your expertise in the medical field. Was he competent? Do you have an opinion as whether Nano Design was competent to make a will on the date in question, whatever that day was? And that's the key question. You can start with that, and then you go, and then you conclude by saying, so it is your, so it's your opinion that this, and this compels the conclusion that he was competent. That's a leading question, but that's a good way to end. Even if an objection sustained, you have put it in front of the jury.
Right.
And then you can ask the last question and be sure he's ready to do that. Well, tell us again, or tell us, if you will, Dr. Cloth, why do you think, or why do you have the professional opinion and reasonable medical probability that Nanodesign was competent to make this will on the date in question? And then you've already told him what he's going to say. He'll give you his point, the same one that they've objected to. And that shows that you are prepared for the objection. If they don't object, you're great. You're golden on your direct. If they come in and object, you're also golden by just saying, tell me your basis for this conclusion. And then he goes the same point you just made.
I have a quick question.
Okay, thanks.
So I'm not sure how much we're going to get into direct in this meeting. So if if this is going to be answered, my apologies. But so specifically for North Shore, I remember the last meeting, I think you talked about how a big problem for North Shore, and I definitely agree with this, is that he speaks in like absolutes, not probabilities. So I assume, based on my reading of the rules, that it would be acceptable to specifically ask, indirect for reasonable medical probabilities, not his absolutes. Even though North Shore believes this is an absolute, it would therefore follow that he also believes it to a reasonable medical probability, which would be more presentable in court. Is that fair, or is that twisting his testimony?
No, that's absolutely fair. Because if he says, for example, do you have an opinion based upon reasonable medical probability as to whether Nanodesign was competent to make a will on the date in question? He says, I do. What is your opinion? He absolutely was not. See, his opinion is he absolutely was not. But you couch the question to make it admissible, and he can say in terms of absolutely. And then what's the basis for that opinion? Dr. Northshire? Well, this, and this. So I think that's absolutely fair. You ask the question properly, and he answers it with absolutes as part of his opinion is absolutely that.
Okay, thank
Good.
you. That helps.
That's great. Any other questions? Is there anything else, Mr. Zygert, that you'd like to talk about regarding to direct questions?
I've actually got Cloth up on my computer. I haven't finished it yet, but I'm going to go through and identify some superfluous questions. And what I'm going to do, I'm not going to change anything. I'm just going to make comments on it. I assume that when I make those, they show up, so you can see that.
Okay.
And I'm hopeful that let me back up and just tell you, the way I practice law with my associates, they'll give me a draft and I will turn it around, red line, with all the changes I think they ought to make. That's a way to make sure I have a product that I can go to the court with. That's not what we're doing here. What we're doing here is trying to encourage and give you insight so that you can do it yourself. So what I'm doing, instead of changing anything you've done, I'm going to make comments. For example, some of the direct, who did Terry Cloth?
That was me.
Yeah. Okay.
Is that Silver? Silver or Katie?
I'm directing Terry Cloth.
Okay. That's Silver.
For example, your question number 9 is, overall, would you say Mr. Design was a healthy human being? That's probably close to a leading question. So the question, a better question would be, in your professional opinion as a medical doctor, what was the state of Mr. Design's health? You see, you haven't said he was healthy in there. You just said what was his condition, and let the witness who you've given the script to say he was overall extremely healthy. Question 14, is it true you heard Mr. Design say ACE before? Again, that is a bit leading. And the better question, that's kind of a cross. The better question is, in your interactions with Mr. Design, how did he refer to Mr. Eubanks? And then the answer would be, well, sometimes he called him ace. And you're able to do that because you know what the answer will be because you told the witness, the person who's playing the part, what the answer will be. And I'm not picking on you, but I wanted to just identify some areas that you can to illustrate what I mean by that. Does that help?
Mhm.
Okay. Is there any other thoughts on direct that you'd like to offer, Mr. Zeiger?
No. I will tell your side of it, the defense side, that you've got a conflict between Northshire and Handlet, and y'all need to really parse through how the direct walks that tightrope between their contradictory position. I was actually pleased, Dean, that you picked that side to coach up first because it's a challenge.
Okay, well, what I would like to do, Sterling, is have you think through some of the things that we just talked about with related to an opening statement. And then I want you to get on your opening statement and do some revisions.
Yes, sir.
Okay, I'm also recording this practice, like you know, so I'm gonna put it up on YouTube as soon as we're done, and I'll send it to you in case you want to re-look at something that we said.
Okay. Thank you.
Katie, and then you send that to me when you're done with it, okay?
Oh, my opening? Okay.
Yeah. And
Yes, sir.
we'll start focusing on working on the opening statement. Katie, you can do the same thing with Mr. Zeiger. You with me?
Yeah. So just work on my opening statement.
Yeah, take the principles we've been teaching about telling the jury what you want to tell them, why it's important, how it helps you win this case, then telling them, and then tell them what you told them. And then, and you don't have to have this perfect. It doesn't have to be exactly like it will be in the end of January, but I want to see that you're putting in, you're investing your thinking into it. And then we can direct the thinking. It's easier to get someone corrected who's moving forward than it is to correct someone who's standing still. Does that make sense? So if you'll send that to him, then I'll help Sterling and he can help you, and then we'll jump into the direct questions.
Okay.
Does that sound good? So
Yes, sir.
could you guys possibly have that to us by Monday?
I can try.
Okay,
I have a lot of
if we're gonna
but
do
yeah.
a practice trial on Friday, that needs to be
Mhm.
at least roughly put together, okay?
Okay.
Yes.
Okay, so really just, and remember, 5 minutes, how long is 5 minutes? Maybe 3 pages? 2.5 pages, because it depends on how fast you're gonna talk, but it's not a lot of writing,
Yes, sir.
Yeah.
okay? Does that work for you, Mr. Zeiger, to be able to see those by Monday?
That'll be helpful, yes.
Okay, and then what we'll do is we'll help give some insights on that, and then help a little with the direct questions before we do a practice trial on those 2 parts on next Friday. And I'm going to talk to Mrs. Taggart. I know this isn't critically important now, but I'm going to talk to Mrs. Taggart. Mrs. Taggart is one of our teachers, and she's the principal of the logic school. And she wants to be involved, but she's limited in time. But she might watch our trial for the direct and the opening statements, and I'll let her decide who won. Okay, so even though it's a beginning practice, we're going to have some competition involved in it. So with that said, is there any other questions?
Yes.
Go ahead, Nathan, you first, then I think Sterling said something.
I think Sterling said no. So
Okay, so go ahead. Nathan.
So something that helped me last year, or not last year, 2 years ago.
Yeah.
Sorry, was really having one-on-ones between like the attorney who's directing someone and the person who's being directed, like just one-on-one meetings to just extensively run through the direct and how you want people to answer, and just in some cases literally just practice answering. I think that would help. For me, actually, especially when I'm a witness, I think that would help me a lot. So,
Agreed.
yeah, if we could schedule those, like for me at least, it would probably help me to have at least one run through before
So just with that,
before
in
next
mind,
Friday.
Silver, you're doing Northshire, right?
Yes.
So that means you would have to have a separate meeting to go over this with Nathan.
Yeah.
Because Nathan, you're directing Northshire, right?
Yes, I'm directing Northshire, and actually, for me, I'm probably more just in terms of for my end of things. I'm a little more worried about like me being a witness and just making sure I have, I'm on the ball on that. So
Okay. So who are you as a witness?
I'm lung. So I think that would be Katie
So Katie,
directing me.
then before next Friday, it would be good if you had at least a one meeting on Zoom or something, or on the phone with Nathan.
Okay, yeah, that works with me.
That work
My
for you?
direct isn't really where I want it to be, but like I'm like struggling with coming up with good questions.
Well, that's why we're practicing, okay?
Yeah.
Sterling, who are you?
I am I have it here.
Okay.
Oh boy. Oh,
Which kid, which student is it?
cross or direct?
Direct.
Oh, it's the Australian guy. I forgot his name.
LeClaire.
Oh yes, Leclerc, thank you.
Okay. So then you would have to have some time to meet with them directly by next.
Yeah.
That's Olivia.
Yeah.
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 Olivia's going to get this recording, as is Kayla. But what I would like, could you guys do this for me? When you have set a time to talk to your witness, either as a witness yourself or as an attorney, could you put that in the stream of Google Classroom?
Yes.
Just like,
Mhm.
this is Sterling, I'm talking to Olivia on this time about that, that just keeps me knowing that you guys are on track, okay?
Yes, sir.
Who's doing Wilson?
Uh,
Because I think I'm acting out.
I think that's Kayla,
Okay.
Yeah. Yeah.
okay?
Hmm.
I'll double check on my notes and I'll let everybody know in the stream, okay?
Yes,
Who
sir.
you're correcting and who you're crossing. Most of you know that, and who's doing who, but just to be clear, I'll put it in the streamer, okay?
Yes, sir.
Any other questions?
No, sir.
Okay, appreciate your all's flexibility. I know it's Christmas break, but like I said, this is when the wheat and the chaff get separated, okay? And I think you guys are a lot of wheat and a lot of fruit, and I just want you to get every benefit you can out of this. So is there anything you'd like to add, Mr. Zeiger, before we close?
No, I don't think so. I'm about to finish up my comments on terry cloth. I would suggest that everybody look at my comments so you kind of get a sense of where I think I'm going,
That's a good
not
idea.
limited just to this.
Okay, that's a good idea. Then what I'm going to do is let you guys go. You kind of know what your assignments are. I'll be watching stream to make sure you're on top of that. And then Sterling, you get that to me before Monday, okay? Anytime. It doesn't have to be on Monday. And I'll start working on it, okay? And Katie, you do the same. Sound good?
Yes, sir.
Thumbs up or something? You with me, Silver?
Mhm.
Yeah, you with me, Katie?
Yes, sir.
Okay, good. Then we all got it. So Does anybody have a final question before we leave?
No, sir.
Okay, well, thanks for your time again. And we will just work independently until Friday, but in preparation to be ready to make as good a shot as possible on this first run. Sound good?
Yes, sir.
Okay,
I'm
well,
looking forward to it.
yeah. Thank you, everybody. Thank you, Mr. Zeiger, for all your help. It's really valuable for us, and we thank you. And you guys have a good first week of your Christmas vacation. One final thing, Nathan, did you get the text I sent you on the thesis?
Oh, yes. Yeah,
It's
I
just a
will get that to you.
document. It's
today.
just a document we need. We're getting
Yeah.
from different people, so that would be helpful. Okay. Anyway, I
Cool.
didn't mean to say that. Thanks for everybody and all of your questions. Really good questions. We'll talk to you soon. Okay.
All right.
Bye bye.
Thank you.
Mr. Murray. Thank you.
Bye.